But good afternoon, everybody. Hopefully you are enjoying some sunshine today, or at least looking at it out your window. My name is Brad Williams. I'm the Vice President of Government Relations at the Detroit Regional Chamber, and welcome to another one of our Restart webinars. We are happy that you are able to join us today. We know that restarting and Restart Michigan is on top of mind for a lot of our members as we are moving closer and closer to the end of stay at home and stay safe order. And the governor, even this morning, announced some new openings with retail and automotive sales. So more and more businesses are getting closer to being able to reopen. So to discuss some of those issues, particularly as it pertains to how employers relate to their employees, we have two special guests with us today from Butzel Long. We have Brett Miller, who is the shareholder and employment practices liability insurance practice leader at Butzel Long, as well as Sarah Nirenberg, an associate at Butzel Long. We thank you both for taking some time out of the day to talk to the chamber members today about hopefully what the future holds for us in the very near future. So why don't we just get started, and I will let you guys jump in as you see fit. What really do employers need to know, and what do they need to do to provide additional training for their workforce as we hopefully get back to work here really soon?
Thank you, Brad. I think that it's really important, first of all, for employers to understand that Governor Whitmer, through her executive orders, in particular the one that was just released today, updated some additional training requirements for employers to keep in mind as they return to the workplace. So you're looking at Executive Order 2020-97. All businesses have to give their employees some minimum training. And then there also are specific additional industry training requirements if you are in manufacturing, construction, and I'll go through those a little bit. So overall, employers need to provide, at a minimum, this is all employers, need to provide training for workplace infection control policies. They need to train their employees on the proper use of PPE, particularly the face mask, which we'll discuss. All employees are going to have to wear face masks pretty much most of the time that they're in the workplace, and you're going to have to train them on how to wear the face mask, that it needs to cover their nose. As we go out into grocery stores or whatnot, sometimes we see people aren't wearing their face mask right, even though they probably know how to wear it. So the governor is requiring that you as an employer show and train your employees on how to wear their face masks. They also need to train employees about the steps that they need to take to notify the business operation of any symptoms that they might be having, COVID-like symptoms, or if they suspect that they have COVID, or they suspect that they're having close contact or living with somebody who is diagnosed with COVID. And they also need to train their employees on how to report an unsafe working condition. So there, like I said, there's also these additional specific industry requirements for manufacturing. You need to, be training them on the routes that the virus takes to be transmitted person to person, the distance that the virus travels in the air. And then they also want you to train them for PPE and how to take your PPE on and off, like particularly your face mask, not to touch the inside, and how to clean it, etc. Retail stores also have more training. They need to really take into account cleaning procedures, how to train the cashiers on cleaning between customers, how to now manage customers that might be symptomatic that are in the store. But that doesn't just involve customers. I also want to point out, you're talking about all visitors. So if you have people who are delivering items to the store, like vendors or something, the employees need to be trained on how to manage and report those people as well. And then you have restaurants and bars. They need to be trained on PPE with respect to food safety guidelines. and how to manage also symptomatic customers that are in the restaurants. And then you have you have cleaning that you need to train them on these sort of cleaning requirements. You need to pay attention to the OSHA regulations. You need to make sure that everything that you're using in the workplace, employees know how to use it, that they have the right PPE. And you shouldn't assume that you can just go to Home Depot, get a bunch of empty plastic bottles, fill them up with Clorox and just write Clorox on the bottle. You still have to follow the OSHA requirements with the labeling for that. So I do want to emphasize, just to end this question, that the more training you give employees, the more I think confident they're going to feel when they return to your workplace that you're instituting measures that are keeping them safe. It's a way for them to buy into it. So besides being required, we really are encouraging all of our clients and all businesses to give their employees a lot of training so that they can understand that their business, their workplace really cares about protecting them.
Well, and a plug for some of the work that we've done at the Chamber. We did a poll that we just released yesterday that covered a lot of territory, but one of the things we asked the public in Michigan was how confident they were in returning to work, and their employers, and a good majority showed that they were confident in their employers to keep them safe. But that really is a trust that is important to maintain beyond the legal requirements too, is to show your employees that you're working to keep them safe. Brett, these return to work and the social distancing policies and the protocols, the PPE, everything that we've been talking about, are these required or are they recommendations? Where is that line between following the letter of the law and going above and beyond? What's your recommendation for employers?
Yeah, no, that's a great question. I mean, first you have to keep in mind that a lot of these requirements, this is required. The personal protective equipment is required. A company has to provide the masks, possibly gloves. That is something that the company is going to have to provide. There are other recommendations based on industry group that might apply, but aren't part of the executive order. We're advising companies that if there's a personal protective gear requirement or recommendation from an industry group, follow the strictest safety requirements. It goes back to that, keeping your employees feeling confident, feeling safe in the environment. But companies do, by law, now have to provide personal protective gear, the masks. The governor's executive order recommends, it does not mandate, but recommends that if employees are working within 3 feet of each other, that they have shields. Again, that would be provided by the employer. The social distancing requirements are also required. And it goes into details on, maintaining the 6-foot separation. Can you tape the floor to mark this off? If you're in offices, are you removing chairs and conference rooms that you're maintaining the social distance? I mean, the rules are requiring this kind of spacing. But it's also important to note that the executive order, particularly for offices, is still requiring or highly recommending everyone to telework where they can. So for those that have to come back to work, now we're facing the PPP and social distancing requirements. Different industries are going to have different rules on this, and the rules are changing daily. As Sarah mentioned, there was an executive order, that came out 3 hours ago that updated some of these rules. So it's important for companies to check the latest requirements through state law and through whatever local ordinance or local executive order might come into place, because these things are changing very quickly.
Yeah, these things do change much more quickly in an environment where it's happening by executive order as opposed to legislation. And it's important, I think, as you mentioned, there are layers to this too, that your local government may have different regulations. And if you're a multi-location business, things may be different in Oakland County and Macomb County. And so it's important to check in with your local governments too, as to what their requirements are. What other safety measures should businesses take, and what are the requirements under OSHA? We talked about some of the state requirements, but what about the federal requirements as well? Are there different or additional requirements under OSHA?
Yeah, so a lot of this is going to overlap. A lot of the things that the governor's requiring you to do as part of the executive order, and that we're also recommending that you do, would make for a safe environment under OSHA. I think that, this is really a new area for all of us, and the best practices with the face masks, keeping social distance, so all the PPE, the social distancing, the cleaning protocols, all those are going to be the things that you need to do to be OSHA compliant. So the other recommendations, again, this is, increase your cleaning protocol. So you want to really pay attention to those high surface areas, doorknobs, pushes, shared equipment, shared vehicles. If we go back to the executive order and then also to local health orders, county orders, you're going to see there's a requirement for screening. So you have to implement that daily screening protocol for anyone entering your facility. And we can go into that in a little bit more depth if anybody has questions about that, what you're required to do. And you should be looking again at your county to see what exactly they want you to ask, because it may be different from county to county. Also, you should be planning a response for third parties suspected of having COVID. I think the biggest thing with OSHA compliance is that you need to have a protocol for notifying employees of a confirmed COVID case in your workplace. The executive order overlaps with this a little bit because it clearly states that if you have a confirmed case of COVID in your workplace within 24 hours, the business needs to notify the local public health department, and it needs to notify any coworkers, contractors, or suppliers who may have come into contact with the person with the confirmed COVID case. And that's why I say it overlaps with OSHA a little bit, because failure to notify the workforce could be a violation of OSHA's general duty clause, which requires you as an employer to provide employees with a safe work environment. The last thing I'll say is we've heard this from some businesses that they're considering utilizing HVAC contractors to increase the number of air changes in your workplace. That sounds like a good idea, so just wanted to share that. But again, a lot of that is an overlap between the executive orders, the local health orders, and OSHA.
Yeah, it sounds like a lot of people are of the mind that there's no such thing as being too careful in this instance. And I think that rings true to me. You mentioned, Sarah, and I don't know, Brett, if you want to jump in here about some of the medical screening that's already happening. I know Oakland County put this in place for essential businesses pretty early on after the stay-at-home order, where employers are required to ask questions of folks coming into work. And so that requires employers to ask employees, medical information, and maybe it's not necessarily the most sensitive medical information, but it's still medical information. In screening, employees may be taking their temperature. What are the employer's obligations in this instance? Because I know, just for some employees, it may, cause some discomfort, as well, having this information being tracked by your employer every day as well.
No, that's a great point, and it's becoming a common concern. I had a client call yesterday with in a healthcare setting with a nurse who said, I don't want to have a COVID test. I don't want anything up my nose, and I'm not taking a COVID test. And what do you do in that case? And that's an extreme example of actually giving a test. But there are mandated screenings, as you mentioned. Different counties have different screening requirements now. So from taking temperatures, asking questions about travel. You alluded earlier that there's different county rules on this. This is an example. In Wayne County, you have to ask if someone's traveled domestically or internationally by airline. Oakland County is more broad. Have you traveled at all? And if they check yes to these boxes, it triggers a whole nother kind of decision tree, because now they're supposed to go home for 14 days. And of course, as you mentioned, all of this information you're getting is sort of traditional medical information that employers aren't used to really dealing with outside of doctor's notes or sort of sickness. Now we're mandated to kind of collect this data on a daily basis, and it's totally different because it's still confidential. The Americans with Disabilities Act has confidentiality rules that require you to protect this information. keep it secure. So you need to then limit who is conducting this training. You don't grab somebody off the street to start screening people. So we have to identify who is going to be in charge of screening, how you're going to maintain confidentiality, and then of course the procedure of just going through the screening process and weeding out people and their answers, and what to do, of course, then if you have people who are checking yes. So it's another layer of complexity, but it is mandated, and it's something that, again, going back to check those local ordinances, check those rules. Oakland County, for instance, has a checklist on its website you can download and utilize. Our firm has materials as well. It's something that's readily available, but something that employers should take advantage of.
Well, I wonder too, Brett, and this may seem silly on the face of it, but I wonder, is there the potential, and how do employers react if employees are taking advantage or gaming the system as well? I mean, I think, the best way it would seem to me to get a day off right now would be to say that you ran a fever last night. You're automatically going to get sent home at that point. And so, what's an employer to do if they suspect that someone's gaming the system right now too? Hopefully that's not the case, but you could see a situation where it might be.
Yeah, that is the case, and unfortunately. So a common question I've been getting in the last few weeks is a scenario very similar to the following. Employee wants to take vacation now. Everyone's back to work. Employee has vacation time and wants to travel to see family. It's been a lockdown. It's time to get out and see family. Wants approval to take the vacation time. 7 days off, okay? But now, when this person comes back to work on the screening, they're going to check the box that I've traveled out of state. And that's a mandatory 14-day self-quarantine. So if you're approving someone for a 7-day vacation, you're essentially automatically giving them another 14 days off. And many companies who are trying to get back up and running and having workers re-enter the workforce can't really afford to give somebody 3 weeks off right now. And to add insult to injury, because that local order would mandate the 14-day stay-at-home period for self-quarantine, it becomes effectively an isolation order under the Families First Coronavirus Response Act, which then triggers 80 hours of emergency paid sick leave for employers who have under 500 employees. And that's a fairly new law that just came out 2 months ago. So when we had a stay-at-home order, we didn't have all of these rules in the workplace. But now you have to consider an executive order, the effect of someone taking vacation on your screening protocols, and whether that's going to trigger federal paid leave requirements. Again, complexities we didn't have to deal with before, but that's just an example of how employees can, in some cases, try to game the system a little bit, and why employers have to be really diligent in terms of interacting with employees on who exactly is going to be needing to take time off, exactly why people need time off, or what their situations are in the workplace that would require perhaps a little more back and forth than employers are used to with their employees.
Right, because it is hard. We try not to dictate how employees spend their vacation time or their time off the clock, but in these instances, it does make a difference in our ability as employers to manage our business. So there are so many things that add layers of complexity in these last 10 weeks, and this just adds to it. Sarah, what can an employer do if an employee refuses to return to work? I mentioned that we took a poll and that most employees feel confident in their employer's ability to keep them safe, but there is a significant minority that doesn't feel safe coming back to work, and I would imagine depending on what industry you're in, that number can grow. What is an employer to do if an employee just says, you know what, I just don't feel safe?
Yeah, so I think that there's two things going on here. I think we need to separate it from people who can do their job at home and people who cannot. So right now, the people who can work from home are working from home if your business has work for them to do. And some of those people, I think I heard a statistic on the radio not maybe 2 weeks ago that said 80% of people would prefer not just that they're afraid to come back to work, but 80% of people who have been working from home would prefer to continue working from home. And so people might want to say they're afraid to return just because they like working from home and want to continue working from home. And so I think in those situations, when you find out that somebody is perhaps maybe gaming the system because they want to continue to work from home, you can refuse to continue to let them work from home unless they're seeking a reasonable accommodation because they have some sort of disability where they feel that they have a vulnerability or something that would require them as a reasonable accommodation to work from home. But putting that aside, I think you really need to determine, especially in the case of somebody who can't work from home, say you're manufacturing, say you are a small business and this person is the receptionist, something like that. They need to be in the office, right? And you really need to figure out what is the reason why they're refusing. Are they refusing because they're on unemployment right now and they're making more on unemployment and they would prefer to stay on unemployment? Are they saying that they're vulnerable and so they fear coming into the workplace? Are they saying that they have a vulnerable spouse and they're afraid to go in the workplace to get something and come back and give it to their spouse? What's the reason? And that's going to let you identify how you need to react. So if they're talking about themselves being a vulnerable person, this is going to trigger the ADA interactive process. Okay, you're going to have to go through with them and their doctor, what are the reasonable accommodations you can make to allow them to return to the workplace? Probably what I've been seeing so far is that for the businesses that have returned, people who have come forward and said that they've had vulnerabilities, they've started that interactive process, and many of their doctors have said as long as this person has this PPE or they have maybe additional PPE than is required by the executive orders, maybe they have a face shield instead of just a face mask, then that's good enough. And so you've resolved that. And so if that employer says or employee says, I'm still not coming back to work, well, that's on them refusing. It's not because you didn't go through the interactive process with them. So that can result in a different sort of dialogue with them in which you may need to terminate that person if they can't do their job and they're refusing to do it, even though you've given them all the reasonable accommodations. So it just really depends on why you need to get to the bottom of why they're refusing to come back to work. And I'll end with, and this is going to come up a lot, you have work available for an employee, but they're making more on unemployment again. And in that case, I just want employers to be aware that employees could be denied unemployment benefits if they refuse to come back to work without good cause. And this could be considered to be fraudulent if they're making misrepresentations to unemployment agency. And that's something that the employer can report as fraud as well. So that's something to keep in mind.
So at what point, so in this instance where we're talking about a vulnerable employee, where does this apply and how does this relate to someone who maybe has a vulnerable family member? So maybe they themselves aren't vulnerable, but their spouse or a family member at home is vulnerable. Does that trigger the same ADA compliance there, or is that then kind of up to the employer's own goodwill, or how's that work?
So if the employee is not the one that has the disability, there's no need to engage in the interactive process with that person. It's very unfortunate, and employers may choose to go above and beyond the call of duty to give them a reasonable accommodation. Maybe you're a small office of doctors, maybe you're partners, and you decide, well, that person's spouse is vulnerable. I can let this person work at home more. I can let this person do all the telemedicine, but that will be up to you as an employer. I will also point out, though, that you don't want to be taking extra steps on your own so say you know that somebody in the workplace, their spouse is vulnerable. You shouldn't be treating that employee differently without them requesting you to do that, because that could be discrimination on the basis of them being associated with somebody with a disability. So in all of these cases, even when the person has a vulnerability themselves, we are always recommending that you wait for the employee to come to you to ask about some sort of accommodation. Even if you know that the person might have a heart condition or might have diabetes or might be in one of those vulnerabilities described by the CDC, wait for them to come to you. Don't start imposing restrictions on them, because you get into a direct threat analysis, and that's a pretty tough analysis to get into, and it's to be avoided.
Would you even go as far as to say that an employer, would it be advisable for an employer to say to a potentially vulnerable employee that if you think that you need accommodations, you should ask me for accommodations? Or is that even that maybe going too far?
I mean, you could do that, but now you are opening yourself up to having to go through that interactive process with them. You don't have to. You can just wait for the person to come to you. What I understand that employers may want to do that, especially if they have a close relationship with an employee, but you're putting so many safety protocols in place anyway for your entire workforce. If somebody needs something extra, let them come to you for it.
And I'll throw in that this is kind of a common scenario we're seeing as well. Employees will actually affirmatively come to the employer with a doctor's note saying, I'm particularly vulnerable and I do need an accommodation, which can trigger, again, that emergency paid sick leave under the Families First Coronavirus Response Act, because now you have a doctor's note to self-quarantine due to a vulnerability. They could get 80 hours of leave for those companies that have under 500 employees. And it can be very broad, because I had a client that had a doctor's note saying a gentleman's irritable bowel syndrome led him to be immunocompromised, which made him more vulnerable to COVID and therefore needed to stay home and couldn't work. You know, and yeah, technically, if you read the Families First Coronavirus Response Act and the regulations, that's protected. He should get leave. And it's going back to your question on gamesmanship. I mean, it's an issue. It's certainly kind of playing the system, but it's putting the employer in a very awkward position where you kind of have to honor these things and be very careful in how you approach it.
It sounds like in a lot of these instances, it's a good idea to have a good attorney, right?
Exactly.
So what about, you know, let's say this is a good case, best case scenario. You know, if you've got a laid off or a furloughed employee who is rehired or asked to return to work, let's hope that happens all across Michigan and soon. But you know, what sick pay and statutory leave benefits are available when that employee comes back?
Yeah, that's a great question. I've kind of been alluding to this Families First Coronavirus Response Act, and that's the first thing that we have to deal with now. The Families First Coronavirus Response Act, FFCRA, contained two new leave laws that apply for COVID-related needs for leave. Okay, so the Emergency Paid Sick Leave Act is one. Again, 500 or fewer employees, that there's no time waiting limit. I mean, if you hire somebody day one, they could get this emergency paid sick leave, and it relates to certain needs for self-care due to COVID, like the example I gave of being particularly vulnerable. If you actually have symptoms of COVID, you can get this paid leave, but it also can apply if you have to care for someone else, or there's been a school closure or loss of a care provider for a minor child. Also, along with the FFCRA was an expanded family medical leave that applies, again, for anybody under 500 employees. And it even applies for those companies who have fewer than 50 employees. Traditional family medical leave that people may be familiar with is a 50 or more employee threshold, but the new law is broader. It even applies for under 50. So, you know, companies who have no real experience navigating this law now might have to provide this potential leave up to 12 weeks for people who have to care for a minor child due to a school closure, loss of care provider. So those two kind of leaves overlap in that one specific area. So that's something that should be considered because in Michigan, of course, every school closed. So you have a kind of large swath of the workforce that may be eligible to apply for this leave, and you have to consider it. There are some exceptions, and there's some different rules and wrinkles and maybe some escape clauses that you'd want to consult your attorney about. but that could be one. There's also the Michigan Paid Medical Leave Act that went into effect last March of 2019 for 50 or more employees. That requires some paid sick leave to be provided that is implicated in COVID-related needs for leave. And Governor Whitmer came out with Executive Order 2020-36 that sort of expanded that Michigan leave law to say that if you have someone, again, there's exceptions, but if a employee has suffered symptoms or has tested positive for COVID, they're not supposed to be fired, discharged. They're supposed to be given time off if they have the paid leave available. They should get that. And again, if it falls under that rule, you're falling under the FFCRA rule of a local isolation or state isolation order that therefore triggers federal leave. So it's very confusing, but it's important to keep in mind that in Michigan, for those who are claiming that they were exposed to someone with COVID or themselves have symptoms, there are some protections, and it's not as simple as just saying, you know what, you can't work. We're going to have to, consider you a voluntary quit or fire you. You really have to make sure that they're not triggering some of these leave laws that are available. And this is just the new stuff, in addition to people who need traditional family medical leave because of a, medical condition or potential, leave for disability under the ADA. Very complicated, a web of new laws. But those are some of the main points I think everyone needs to consider is when they're drafting their reentry plans, make sure they have that FFCRA policy in place so that they can at least have that aspect covered.
So Brett and Sarah, I don't know if this falls in within either of your areas of expertise, but Brett, since you just brought it up, certainly something that I've been thinking about as a parent, and I'm guessing a lot of parents have, and you mentioned it, Brett, that schools have been closed for several months now, and I think for a lot of parents, their summer plans have been thrown into disarray with various camps and activities being closed. So there's going to be a lot of parents who are scrambling for childcare, at least until September. What liability concerns should employers have? There's a lot of times where you'll see, a kid show up in the workplace, for a day, maybe during a snow day or something like that. But my guess is there's going to be temptation to have that happen more often. Are there liability concerns that employers should be thinking about in those instances where childcare is going to be a pressure on a lot of people through the summer?
Yeah, absolutely. I mean, keep in mind that as of right now, a lot of the executive orders are limiting who can even be in a workplace. A lot of landlords are limiting who can come into a workplace, gathering sizes, everything else. So, bring your son or daughter to work day is going to be off for a while. And that's probably going to be banned from most workplaces. But that doesn't really solve the childcare problem, right? And many families will be scrambling to find coverage. And again, if the business is under 500 employees, they're going to look at whether they need to provide some of that leave, potentially paid leave, if a parent simply doesn't have any coverage for the kids. Now, the regulations have come out and said that there has to actually be a need, that there's no one else who can provide care. The care provider is if you have a spouse who's at home, who's off for the summer or doesn't work, you can't then just say, well, I need leave anyway, because there is another care provider. Enforcing that, of course, as a practical matter, is far more difficult for employers. We have forms that we provide clients that have a check to certify that this kind of need is required. But it's going to be an ongoing issue. I mean, employers are going to need to really work to see who can work from home and remotely while the kids are home, whether there's a need for this leave, or really how to balance that with the workplace.
So with OSHA reporting and workers' comp benefits, how do those apply if an employee contracts COVID-19 while they are at work?
Yeah, so I'll break this down. It's really two questions. So I think that when you're just looking at OSHA reporting, you need to follow this new guidance that just came out. The OSHA previously had guidance, and a couple of days ago they retracted it and updated it. And so you're really looking at starting, it's effective May 26th. It's requiring an employer to document a confirmed case of work-related COVID if it involves one or more of the following. And these are the standard, death, days away from work, restricted work, transfer to another job, medical treatment beyond first aid, loss of consciousness. I think the key one here is going to be days away from work, because once you have a COVID diagnosis, you're mandated to stay away from the workplace. It's probably going to be different if this person can work from home. Say they, are diagnosed with COVID, but they have a very mild case and they can still work from home, then that would be different. But that's, we're probably not, going to see a lot of cases like that when your employee can work from home while still on COVID and wouldn't lose any days of work. So what you're looking at right now, the big question is going to be, what does work-related mean? Because everybody knows what COVID diagnosis is you have a positive COVID test, right? So work-related is going to be the difficult thing for an employer to investigate. But OSHA requires you to make a reasonable investigation to determine whether the employee got COVID at work. And they've given some guidance for employers on how to do that. They first say that you as an employer, you don't need to undertake this extensive medical inquiry. It's enough that you ask the employee how they believe that they contracted COVID. What sort of out of work activities have you been engaged in that may have caused this illness? And so you want to look at those responses and try and figure out generally, the big thing is, did somebody else in your workplace have a diagnosed case of COVID, and was that person who's now diagnosed, did that person have contact with that other employee that had COVID? So you need to be looking at all the information that's available to you at that time, which means if you learn something later that would change your answer, you need to update your answer. So say you learn something after that, the employee, Susie, had contact with Jim and Jim had been diagnosed. Well, now you know that since Susie had contact, maybe this is enough to cause you to make it reportable. You need to go back on your log and change that. And so what OSHA, the guidance has done is they've listed factors that they say weigh in favor of designating the infection work-related, unless there are other alternative explanations. And so those include, one, several cases develop among your workers and the person had close contact with them. The employee contracted COVID shortly after a lengthy exposure to a customer, or again, a coworker, or it could be a vendor or somebody else that had a confirmed case. Also keep in mind another one is the employee's job duties include having frequent close exposure to the general public and a locality with ongoing community transmission. And so where we are, if we're in a hot spot, then if the job duties are having contact with a lot of people, that's going to be a factor that OSHA says, really weighs in you putting that case on your log. And then you're going to want to look at whether they've had any close contact with somebody outside the workplace. Again, if that person was likely to be highly infectious. The final, I think, really big question is, okay, so say you as an employer went through that entire reasonable investigation and you still can't figure out, you can't determine if it's more likely than not that this person was exposed at work. Then OSHA says you don't have to report it. But because OSHA did just change that guidance, it's possible that it could change again as more information keeps on coming out. So it's something that you just, again, have to keep on going to the website to check out to see if it's been updated.
So as we've been sitting here too, people have been sending questions in through the question box. And so I've been monitoring that as well. And so I'm gonna ask a couple questions that folks who've been listening in have asked. There's a lot of questions about what can be required. Can an employer require a COVID test in order to come back to the office, or to take that even a step further? I mean, Lord willing, we're going to have a vaccine before too long. Can they require that once we have a vaccine, that an employee take or receive the vaccine before they come to work.
On the test, yes, you can require now a test for COVID. The EEOC has come out with guidance on that. Of course, there may be accommodation issues you have to consider, but tests are readily available. You can require it, and that is now established. So some entities are really setting that up and doing it. If you're a construction contractor with the city of Detroit, for instance, the city of Detroit mandates that your workers get a COVID test before you can show up on the job site. So there's moving parts of that, but generally, yes. On the vaccine front, of course, we're not there yet, but our guess is it's going to fall within the sort of other typical rules that you see for vaccine, like mandatory flu shots, where there can be carve-outs for religious exemptions, requirements, and there might be an interactive process that you have to engage in. But there would be, nothing in the law at this point that's preventing a vaccine to be required for your workforce, as long as you have those, accommodation procedures set in place to really, help protect the workers and keep the curve flat, so to speak.
And then again, as far as communicating with your employees, if you do have a positive case in the workforce, how specific should employers be? So for example, if I were to test positive, should the chamber tell the rest of the employees at the chamber that it was me who tested positive, so that people can know, do the contact tracing, or how? I understand that's violating some privacy too, but how do you do the best contact tracing possible?
Yeah, Sarah and I were both shaking our head on that because
I saw that. I realized I said something stupid as soon as it came out of my mouth.
Well, I'll tell you that. So the privacy aspect is an ADA requirement to keep medical information confidential. So if you have a positive test, as you indicated, you can't say who. But I have a form that I provide to clients that's valid in Michigan that can be a voluntary waiver of that ADA confidentiality requirement. Because if I tested positive, I would want people in my workplace to know, hey, you were around me. I want you to know it was me, and take whatever steps you need. So employees could voluntarily sign off to kind of excuse that confidentiality. But the other steps to that are going to be, I think, kind of Sarah was mentioning earlier, and can walk through the OSHA process. But you need to do the steps, the disinfecting, the risk assessment of who was exposed, who was around the person, were social distancing guidelines maintained, have you done the reporting that you need to do, and really kind of walk through that checklist and you mentioned contact tracing, because some companies are actually putting this stuff, or considering rolling out mandatory apps that will allow contact tracing as part of the device management protocol for people who have BYOD or get reimbursement through the company for their cellular phone, for instance. So these are all kind of ongoing considerations. And Sarah, you may want to jump in with some of the additional OSHA requirements.
I mean, I think that beyond, an application on your phone, which even if you had that, you have to assume that the employee has their phone on them, because if you work in an office like me, I typically, as a woman, I don't have a lot of pockets. So I put my phone on my desk and then I go walk around my office. I don't know how much it would really make a difference if you're using on that to rely on it for contact tracing. I think what you're really going to have to do is sit down with the employee, probably by phone, and ask them, who did they have close contact with in the workplace over the last couple days? Where do they spend the most time? Maybe you already know that because this person is, in an office or in a cubicle. That's where they typically stay. Who is around them during that time period? Maybe they work on a line. Okay, you need to look at their schedules to see, who they interacted with close to on their line. Maybe you get their supervisor involved. So those are ways to do contract tracing to try to establish who they had contact with and what areas in the office they typically go to if you don't have an app. I think that's really the only thing I have to add on that point.
And I'll note our firm has a a checklist that we provide to some of our clients that have common, return to work issues and things you need to be considering as you are planning a return to work. And one of the sections, of course, is kind of exactly your question. What do you do if someone does test positive? You can kind of pull out the checklist and go right down through. So if a company doesn't have something like that yet in place, it's certainly something to consider so that this stuff is kind of automated.
Okay. The last question I have for you, and this again comes from the audience, is about PPE, and where it's required in the workplace. Is that the responsibility of the employer to provide it, or is it the responsibility of the employee to provide their own PPE, or is it a mix? Is that kind of at the discretion, of the employer, depending on the workplace? For example, I've got a really cool Stormy Cromer mask that I bought, Michigan made. Can I bring this to work and not wear the paper mask that Sandy's going to have to provide for me?
The executive order says the company is supposed to provide it. It's supposed to be employer provided. This is a little more difficult for remote workers or people who don't go to a central office site. And I've seen some employers kind of offering to reimburse for PPE that they can't, physically hand out to an employee. But the general rule is supposed to be that burden's on the employer to provide the right protective equipment at this point.
Okay. Well, Brett and Sarah, thank you very much for spending some time with us today. It's very, very helpful. I know I learned a lot, and I'm sure the folks who were listening in learned a lot as well. This session was recorded, and it will be available on our website at detroitchamber.com/COVID-19. And I know Brett and Sarah at Butzel Long are also available and are more than welcome or more than happy to take your business if you need further advice. So thank you very much, Brett and Sarah, for your time today. And thank you everyone else for listening in. And we look forward to having you join us again soon.
Thank you.